Okay.
Hi, this is Reen. Sounds like Green. I'm a Minnesota realtor and I help families get through probate with more money and less stress. And today I'm joined by attorney Heather Balgaard from the law firm of Monroe, Moxness, and Berg here in Minnesota. And Heather has a lot of unique experience making probate accessible to all families. Heather, welcome to the show, and please take a moment to tell us a little bit about yourself and what drew you into probate and estate planning.
Absolutely. Thank you, Rain. So I've been a lawyer for 14 years. I spent about 7 years of that in the corporate world. So that's where I started right out of law school. But within a couple months of passing the bar, starting my corporate job, I thought, you know what? I really went to law school to be a lawyer. I love my corporate job, but I want to help people. So I started practicing estate planning on my own on the side and eventually grew that practice and ended up joining a firm. So I left the corporate world and I've been doing 100% estate planning, probate, and trust administration since 2019. Um, what really drew me to probate was, again, helping families. I personally have been through the grief process myself. It is unlike anything you can expect until you go through it. I am a very empathetic person, but I'm also very like practical and able to break tasks down and get things done. So probate felt like a good fit for my particular personality and skill set. And as I've been practicing and working with families, I think that's absolutely proven to be true. I like to come alongside people and say, hey, this is a horrible time, but I got you. I got you.
Mhm.
And I strive to make it as seamless and easy as possible.
Heather, I really commend you on sharing that part of the thing that drew you into probate work was your personal experience. On the real estate side, that's one of the things that drew me into probate work as well. I ended up as a personal representative, and I always describe it as the worst job I never wanted. And there's no training, right?
Yep.
You just have to get through, and then you get a lot of bad advice from family. And so when someone like you learns from personal experience, it's really nice that you can come back and help families going forward and really help them avoid some of the mistakes that I made and maybe you made as well.
Yeah.
So
Yeah.
that is awesome. One of the things I noticed on your website is that it says that you have experience helping low income families through probate. And could you talk a little bit about that? We get a lot of questions in the Facebook group, families who are either low income or maybe they're on disability and they're looking for legal help. I always recommend they get legal help, but they seem that not everybody can find it. So, what are some of the things that you do to help low income families, or what is some of the advice you would give to them?
Yeah, absolutely. So one thing I do is I work with an organization. The acronym is SMIRLS. It's Southern Minnesota Legal Resources. And even though it's Southern Minnesota, I'm located in Edina. I work in Minneapolis. It serves people all over. So a lot of attorneys like myself are practicing attorneys with their own book of business, with their own firm, but we like to do these pro bono hours to help someone that can't come up with a retainer or afford an hourly fee. So that's one way that I like to give back. I know a lot of other probate attorneys do that as well. So I would say if you qualify for their income threshold, that's a great way to start. If you are above their income threshold and don't qualify for free legal services, do not be afraid to pick up the phone and call an attorney. I always try and make it work for any client that needs help, especially in a probate. So one thing we can do is we don't collect a retainer necessarily in probate. A lot of people who've either consulted with an attorney or been through a court proceeding, usually they make a call to an attorney and they're told, I need a $5,000 retainer before I can do anything. We don't do that. We will say, okay, we're going to get started. And once you collect the assets or the house sells, then you can settle up and pay the bill. And
Mm.
sometimes we can send an invoice directly to the title company and the legal fees are paid right at the closing. So we do try and make it accessible to people like you who find themselves in a personal representative role and they weren't planning on putting up a couple $1,000s for legal fees.
Oh, that is fantastic. And as part of that process, do you offer a free consultation as well, or do you determine if they're eligible for the assistance before you meet with them?
I do offer a free consultation. So, even if I'm going to point them in the direction of the free legal resource, I always do free consultations with my estate planning clients, probate clients, trust administration, anyone who needs it.
Oh, that is fantastic. I've worked with some families who um, and probably you have too. They started out on their own and they say that they think it's an easy one, right? This is an easy one, shouldn't cost that much, and then they get caught on something. Or
Mm.
sometimes they'll start asking me about forms and I'll say I'm not an attorney. I can't help you with your forms, you know?
Yeah.
And it is amazing how much assistance a good attorney can provide, and some people just don't realize it until they're either it's too late or they're just stuck.
Yeah, absolutely. Yeah.
What are some of the challenges that you see families face? Well, let me ask a different question. Is there a way that a family could do estate planning if they have limited resources? Is it something they should consider, even if they think they might not have enough resources to protect?
I'm glad you asked that because I've had people say to me, I don't need an estate plan. I don't have any assets.
Hmm.
And then you look at them and you go, well, do you own a car? Do you have a bank account? Do you have a 401k? Like you have assets, right? Like people
Right.
think of estate planning as like a, giant castle and a trust fund kid. It's like, no, it's much simpler than that. If you own stuff, you need an estate plan. So I have a really interesting example from my own family. I had an
Mm,
uncle who was severely disabled, lived in a group home, had $600 to his name,
mm,
and he's my great uncle. So my uncle called and was like, should we do an estate plan for him? I was like, I don't think he needs one, but let me look into it. And sure enough, we discovered that my great grandfather had gifted him some piece of land
mm.
in the Cloquet River that was owned in his name. And if we hadn't have done any planning, we would have had to do a probate for like a $3,000 piece of land. That was his
Right.
only asset. So, so that's the point to make, that everyone needs an estate plan, even if you don't think you need one. Now, not everyone needs to do a $3,000 estate plan, right?
Hmm.
When you think meeting with an attorney, you see dollar signs and you think, oh my
Yep.
gosh, I'm gonna make so much money. My advice is, if you don't have a lot of assets, but you do own any type of real estate, even if it's only a $3,000 lot by a river, any type of real estate triggers a probate. So if you have
Hmm.
any type of real estate, if you have cars, checking accounts, savings accounts, investment accounts, just talk to an attorney. Even if it's not a probate estate, an attorney can give you advice on making sure that everything is set up to be payable on death or transfer on death, or to set up a small trust to avoid probate. I think an hour-long conversation can save your loved ones thousands of dollars and
Hmm.
hours of work. Even if you just say, I think I can do it myself, but let me pay an attorney $250 to just have an hour for them to look it over, I recommend you do that.
That's great advice, and I see that as well. Even on the real estate side, we will have families who assume they don't have to go through probate because they had a will, and they think that that
Yes.
authorizes them to do everything they need. And then they will want to list their house, and I will mention to them, if we don't go through probate, technically you're not authorized to even list this house. Well,
Yeah.
and that, another realtor told me I could.
Yeah,
Like, okay, well, when you get to closing, you're not going to be able to close because you're
exactly.
not authorized. And then that can really set that family back in time and money as well. So
Yeah, absolutely. It's definitely worth it to trust your experts. And I feel like I trust the real estate agents a lot, and good real estate agents will also consult with the attorneys. So
100%,
all about
100%,
partnership.
100%.
Yeah.
So what are some of the other mistakes that you see families make when they try to handle probate on their own? Do you end up getting clients who start on their own and then maybe come to you for help?
So I haven't had a client get as far as petitioning a court, but I've had
Okay.
clients come to me thinking, I can probably do this on my own, but I just wanted to like ask you a few questions. And when I
Mm-hmm.
start to describe the process, by the end, they're like, no, I need you to do all of it.
Mm-hmm.
Probate is a very, even though Minnesota's reformed it and has an informal process now, it's still a very like archaic process, right? The thought of
Mm-hmm.
having to publish notice in a physical newspaper,
Yep.
right? Having to have a certain creditor period, having to get certified copies of certain documents in order to do this. It's a very process oriented, step by step, kind of strange beast.
Mm-hmm.
And so a lot of times when someone comes to me and they're like, I just have to fill out a few forms, right? And I'm like, well, no, this is how it works. They'll just look at me and go, okay, I don't want to do that on my own. So I haven't seen anyone like mess it up too badly because I usually thankfully can stop it ahead of time.
Mm-hmm.
Um, where I see the most kind of mistakes is when people try and do the planning on their own ahead of time. So they might come to me when a loved one has died and they're like, I need help with the probate. And then we look at the will or we look at the trust or we look at whatever they did. And that's where I go, oh, goodness, you really should have consulted an attorney. Um, yeah, so I've seen a lot more mistakes on the front end and the planning piece than on the probate end. Because by the time you're in probate, you you just have no choice but to clean it up through the court system. So
That's true.
yeah,
That is true.
yeah.
Let's see. When you think about probate administration, um, what are some of the things that you do to help a family? And actually I should clarify first. As an attorney, you're typically representing the personal representative. Do you also work with the family members, or do you solely work with the personal representative?
So it really depends. In probate, I technically represent the personal representative, but we, excuse me, like to
Mm.
keep the families informed,
Okay.
especially if it's like mom and dad died. They appointed brother as the personal representative, but there's three other siblings. We don't want it to feel like brother's in control. You guys don't get to know what's going on. Just trust us and we'll tell you when you get your money. So I always write a letter when I send them a notice and I say, just so you know, I legally represent the personal representative. You have a right to hire your own attorney. And if you do, please have them contact me. But otherwise, I'm happy to talk to you. I just can't give legal advice.
Okay.
I think that's a really great approach because when someone is going through grief and they just lost a parent and one sibling's in charge versus the others, there can be some mistrust or questioning or even jealousy. So I
Mm-hmm.
find that being transparent and being open and communicative really helps. So yes, I only legally represent the personal representative, but I am willing to talk to beneficiaries about the process and where we're at with it.
Excellent. And then do you, beyond some of your initial letters that you send out, do you continue to communicate with family members, or do you delegate that to the personal representative?
It depends. So whenever it's something that is requiring a court filing. So if we're doing a
Mm,
formal probate, I'll usually communicate, here's the court hearing notice, you're welcome to attend. And then on the back end, when we're doing creditor claims, final account, that sort of stuff, I always send out communications to everyone before we make disbursement saying, this is the final account,
mm,
here's everything that was spent, and give them an opportunity to ask questions and understand it.
yeah.
And then before they receive a distribution, I have them sign a receipt saying, okay, yep, I reviewed it. I had an opportunity to get my own attorney if I wanted to. So I want to make sure that everyone they don't just feel like the personal representative went spend a ton of money and now you get pennies or you get
Mm,
whatever's left. I want them to feel like they have an interest and a right to represent themselves. So I communicate with them in that. And then in the trust administration world, I know that you specialize in probate, but if you
mhm,
haven't already, I'm sure you'll cross selling houses out of trust, right?
mhm.
There are times where I just represent beneficiaries. I've had families come to me and
Oh,
they say, brother's the trustee. I don't like that he's doing A, B, or C.
mhm.
And I'll represent the beneficiaries then to make sure we're holding the trustee accountable to make sure everything's is being done right and in the best interest of all the clients or all.
And we do get a lot of questions on that topic in our Facebook group as
Oh
well.
yeah.
People asking about the trustees and holding them accountable.
Mm.
And are you typically able to do that without litigation, or sometimes does it end up in litigation?
So I always try and avoid litigation if I can. It's going to
Mhm.
cost the trust money, and at the end, that's money out of the beneficiaries' pockets.
Right.
So I typically like to start with a letter, a demand letter, just we have some concerns, we would
Hmm.
like you to do this. And if they lawyer up then, and we don't get anywhere with initial negotiations, then typically a lawsuit is filed.
Mm-hmm.
But most of the time, we end up settling, whether it's in mediation or just through settlement negotiations with the attorney. I think
Okay.
everyone gets to a point where you have to do that analysis of, okay, in my pocket, I'm fighting over this dollar amount. It's going to cost this much to do a trial.
Right.
Is it worth it? And so we have all of those discussions before we go through a full-blown trial.
Okay.
Mhm.
That's excellent. I have not been through trial, but I know people who have, and it's difficult for some people.
It is. It is. It's you're completely giving control to a judge, complete control. At least in
Mm-hmm.
mediation or negotiations, you are still the decision maker, right? You have to make some
Mm-hmm.
concessions if you want to get it settled, but you still can make the decision for yourself. When you're in front of a judge, it's kind of all or nothing, and it's
Right.
very risky. So I prefer settlement. I think that's always best for the parties.
100% agree. I want to shift gears a little bit and just talk for a few minutes about elder care and some of the mistakes that people make with elder care. Another common question that I get is, how can I avoid probate? Now, a lot of people I'm dealing with, that question comes after someone has passed away. But I know enough to know that you can avoid probate by taking some appropriate steps ahead of time, and it also can have a big impact on elder care. So, could you just take a few minutes and talk a little bit about the kind of work you do for families in that space and some of the mistakes that you see them make?
Yeah, absolutely. I'm going to kind of separate that and answer two different buckets. So bucket
Sure.
one is probate avoidance and bucket two is like elder planning. So when
Yes.
I say probate avoidance, that applies to anyone again that owns an asset. I, have specific recommendations on how you can make sure that your loved ones don't have to go through probate when you pass away. When I think of elder planning, I think of people saying, I don't want the nursing home to get every
Mm,
single
mhm.
penny, right?
Right.
So similar things, but two different. So in the probate avoidance, there are very simple things you can do. You can spend a couple $1,000s, a couple $100s, whatever is in your budget, whatever, is your need, fits your needs. But you can just take a little bit of time, a little bit of money to make sure that you either have a revocable trust set up,
Mm.
or you have a transfer on death deed and beneficiary designations on all of your assets. And that just makes the whole process a lot smoother, a lot cheaper, and a lot faster after you've passed.
Absolutely.
When it comes to elder care, this is where I see the most mistakes. So it is wild, the rumors that fly around. I've heard, oh my gosh, the nursing home was in my mom's house taking her jewelry. No, they
Hmm.
weren't. Like, I'm sorry, but they weren't. Like,
Right, right.
no, the nursing home billing people aren't going to go to your mom's house and take her jewelry, right?
Yep.
But there is this really big fear about the nursing home getting everything and nothing being left for the children,
Yes.
or the loved ones left behind. So there are some things you can do, but a lot of these rumor mills have ideas floating around that sound really easy and people just run out and do it. And it's not right. You have to consult someone. So I can give you one specific example.
Hmm.
So a lot of people here, if I transfer my house to my kids while I'm still alive before I go to the nursing home, then when I die, even if I've been on medical assistance and the state paid for all my nursing home care, they can't collect anything from my estate. It all goes to my kids. So a lot of people are just writing quick claim deeds like crazy and gifting that house to the kids.
Hmm.
But what they don't realize is that your children, when you die, inherit your house with a stepped up tax basis.
Mm.
Okay.
Hmm.
So if I bought my house 60 years ago for $30,000 and I've lived there for 60 years and now it's worth $400,000.
Right.
If I sign a quitclaim deed to gift that to my children now while I'm still alive, they inherit my $30,000 tax basis.
Mm-hmm.
They don't, I mean, I should say inherit. They receive my
Receive.
$30,000 tax basis. They do not have homestead status.
Mm,
So they sell it and they pay a 40% capital gain tax on that gain from
mm.
30,000 to 400,000. That's a lot of money out of your pocket
Yes.
just to avoid a potential maybe we're going to be in a nursing home.
Yeah.
So if you hang on to that house, mom passes away, the kids inherit it at $400,000. They turn around and sell it. There's no capital gain taxes.
Mm,
So a lot of people need to be smart and think, is it likely that mom is going to be in the nursing home? Is it likely that she's going to be in the nursing home sooner than 5 years? If the answer to that is yes, then it's not worth it. If the answer to that is no, now you have to do a cost benefit analysis of how much capital gains are we potentially going to pay? How much nursing home are we potentially going to pay? So it is a very complicated analysis. There's a lot more factors than people realize. And
mm-hmm.
that's the most common thing I see is people just signing a quick killing deed, running to the recorder's office, giving their house to their kids. And I just recommend do not do that. Talk to an attorney first.
Wow. You may have just saved many people thousands of dollars with that advice.
I hope so.
Oh my goodness.
Yeah.
That's amazing. And now the conversely, if they do a transfer on death deed, does that eliminate the risk of the step up basis and the capital gains?
That's a great question. So a transfer on death deed, you still get the stepped up tax basis.
Okay.
So a transfer on death deed is a great tool, an amazing tool. And Minnesota hasn't even had it for that long. I think maybe a decade.
Mm-hmm.
But it avoids probate. It still gives you a step up in tax basis. It's a very simple document to fill out, record. There's a couple things you need to know about insurance. That's a new law that just came out in April 2024. But the one thing it doesn't avoid is that nursing home claim. So a lot of
Mm,
people don't realize that if you qualify for medical assistance,
mm-hmm.
right, the state will pay for your nursing home care. But then when you pass away,
Yeah.
before you can use that transfer on death deed to transfer the house to your beneficiaries, you have to apply for medical assistance clearance.
Yep.
And if they have a claim on the house, you got to figure out a way to satisfy that before it transfers. So that's why I think a lot of people do the quick claim deed thing, but there's issues with that too. So,
Yeah, we see that, and sometimes they don't realize that they need the certificate of medical clearance, and maybe
mm,
I'm thinking of one case where the personal representative was not working with an attorney,
okay.
and then also chose his own title company who wasn't familiar with the certificate of medical clearance.
Okay. Got you. That's a problem.
So guess who had to work on that?
Yeah, you got to clean up the mess.
Oh boy, yeah, but that is that's again just spending a little bit of time speaking with an attorney up front and knowing your options and identifying some of these risks can be the difference between spending a few $1,000s versus 40, 50, $100,000, right?
Exactly. Yeah.
Unbelievable.
Yeah.
Um, that is, and then when it comes to elder care,
Mhm.
um, are there other mistakes? Those were some huge golden nuggets you just gave us, but are there any other areas where you see people make common mistakes that could be avoided?
Yeah, I would say definitely make sure that you have homestead status on your house
Mm,
because if you do need to go into a nursing home and you have a spouse that's still living in the community, or if there's a chance you'll go back, they're not going to count anything that's homesteaded
mm,
as part of your assets available to pay for your care.
oh, okay.
So just make sure, when you bought your house, you're supposed to apply for it. Just make sure you have homestead status. Oftentimes, when people do set up a revocable trust for estate planning purposes, they'll transfer a house to the trust. And
Hmm.
again, that's a great time to make sure you apply for homestead status, make sure that it's on record that it's now with a trust. So I would say that's a big one. And also like educate yourself before you just sell the house or transfer the house. Because
Right.
again, if you have a spouse that's still living in that house, you can still qualify for medical assistance without having to sell it to pay for your care. So
Oh,
they're not,
wow.
yeah. So there's some exceptions for homesteads. Also with people that have like several lots, I've seen people
Mm.
that, have the house, bought the lot next door, and they homesteaded this, but they didn't homestead that.
Mm-hmm.
And so
Yep.
then when it's time to go to the nursing home, they say, well, this is exempt, but that lot's not. So just think about those sorts of things.
Just a little bit of time with an attorney.
Exactly.
Oh my goodness.
Yeah.
Wow. What about are there again when it comes to assumptions and rumors? I know even people in my family make a lot of assumptions about custody. Are there any tips related to custody of an elderly parent or someone in the family that maybe it's just a misconception and you'd
Yeah.
like to clear it
So
up?
are you talking about like having an elderly parent that's under like a guardianship or
Mm-hmm.
conservatorship kind of thing? Yeah.
Mm-hmm.
So one thing I would say, guardianship and conservatorships are really an interesting topic since the Britney Spears thing. I don't know if
Mm-hmm.
you
Yeah,
followed it
yeah.
at all. But as an attorney that practices in guardianships and conservatorships, I thought that was so interesting because this whole movement is like free Britney and like
Right.
she has no rights and blah, 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 blah. And so I feel like it got a very negative, like the perception of that was out there is that this is like a tool that's used to control you and take your rights away, right?
Mm-hmm.
It is very powerful. It does take a lot of person's rights away, but it can be a very helpful and important tool when you have an elderly parent.
Right.
The court will ask you to try less restrictive means before you run for a guardianship and
Mm.
conservatorship. So, what I advise my clients to do is when my clients are still fairly young, like 60, 70, I recommend that they execute a durable power of attorney to
Mm-hmm.
appoint their spouse and then an adult child or someone they really trust as an alternative power of attorney. That way, when they do start to slip or need some help, they don't have to go through the guardianship conservatorship route.
Right, right.
I also, when I have a young couple, like a 40s, 50-year-old married couple, I always have them execute a durable power of attorney upon the spouse, because I don't know if you've ever ran into this, Green, but if I was in an accident and I'm incapacitated and my spouse wants to sell the house, that gives them the power of attorney to sign off on behalf of me if I can't.
Mm-hmm.
So I do think that there's planning that you can do to avoid the extreme of a guardianship and conservatorship. And the other one is a healthcare directive. So usually if
Sure.
you have those two things in place, it gives you enough power to help your elderly parent. It still gives that elderly parent autonomy. It doesn't strip them of all their rights, right? But it's kind of there in the wings for when they need help. When that's not enough, a guardianship and conservatorship can be a really, really helpful thing. But
Mm-hmm.
like a personal representative, it is hard. The reporting
Mm.
requirements, the details, you have to keep every single receipt for everything you buy for mom or dad. It's hard work. So I do
Sure.
think, yeah, think twice before you run to guardianship or conservatorship.
Well, and I have one more question on this topic.
Yeah.
I know that there are some people in our Facebook group who occasionally will talk about, and there seems to be a lot of mixed responses on this. So I'm not sure we actually have received accurate information, but
Okay.
the topic is if an elderly parent does go into a nursing home, there are some people who believe the nursing home can or will apply for guardianship to try to get control of the assets before someone in the family does. When, in a situation where there might not be a durable power of attorney or a trust or anything else. So
Sure.
does that happen? Do nursing homes apply for guardianship over the family?
Yeah, so I saw a movie about it, but I've never
Uh-huh. My
seen it in
mom
real
talks
life.
about that movie all the time.
The I care a lot. Yeah. That was another not great vision of elder law. I've never seen it in real life. So in Minnesota, your family has the priority to be the guardianship or conservatorship, and they are
Okay.
interested parties. So if a nursing home was to make a move to become the guardian or conservator over your parent, you would receive notice of the
Mm,
petition and notice of the court hearing, and you would show up and you would say, Judge, no, 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 I'm
Yep.
the child, I object. So at least in Minnesota, I think it's very unlikely that that would happen. Um, I have seen like the Department of Human Services get involved if the family is financially exploiting or if there's
Mm,
concerns about the family not treating mom and dad very well, then the
hmm.
Department of Human Services would get involved and they could petition to have a professional conservator appointed, but that's usually not the nursing home. So
Okay.
yeah, that movie was terrifying, and thankfully, I've never seen anything like that in real life. So, at least in Minnesota, I think
Hmm.
we have a much better system in place. So,
That's funny because in addition to the Facebook group, my mom and my sister have watched that movie a few times,
okay.
and that's the case study they always bring to me, and I'm like, and I assumed what you just said, but I'm
Yeah.
not an attorney. I don't know for sure, right?
Yeah.
So like
Yeah.
if they call, I will show up in court and try to stop that from happening. But
Exactly. So, I guess the answer to your Facebook group is check your mail, open your
mm,
mail, and show up in court if you get a court notice. That's the best way to.
yes,
So,
absolutely. Speaking of the Facebook group, I'd like to run through just a few questions from the
yeah.
Facebook group. One of them is, and I will confess we don't have all the information here, so we're going to have to make some assumptions. But the first
That's
question
okay.
is, what is the purpose of having a will if it isn't going to be recognized? And they said, for example, when an automobile paid is paid for in cash in dad and the stepmother's name, but it was left to a sister in the will, she gets nothing. Apparently, I'm assuming the stepmom is still has it. She's still, I'm assuming stepmom is still alive and still driving the car, but it was left to the sister in the will.
Okay. So I think I'm understanding the question. So
Mm.
what I've seen a lot is that people mistitle assets and then have something contradictory in the will. So let me
Uh-huh.
give you an example. We'll use a house because you're a real estate agent, right?
Mm-hmm.
So I have two kids and I write a will saying I don't have two kids, this is hypothetical.
Yeah.
If I had two kids,
Yeah. Yeah.
write a will saying everything to my two kids, but then I get married and buy a house as a joint tenant with rights of survivorship with my spouse.
Mm-hmm.
My spouse, as the joint tenant with rights of survivorship, gets that house because we're
Yep.
joint tenants. And then my children don't get it until my spouse dies. So it sounds like that might be what happened. And so I'm so glad you asked this question because when I was talking about mistakes, that's a big mistake is people title things one way and have their will the other. The way it's titled is going to trump. That
Mm.
also happens with transfer on death deeds. We had
Mm-hmm.
someone do a transfer on death deed to six children and
Oh.
then did a subsequent will saying my probate estate is only going to my three children. But the
Oh.
transfer on death deed trumped the will because the will only manages your probate estate. If you
Mm-hmm.
have something titled to avoid probate, the will has no bearing on it. So it sounds like that's what happened with the car.
Right. Right.
So titling is really important.
Absolutely. And there was another question about a quitclaim deed, which you have answered.
Okay.
This one is about a parent's ex-spouse. So I've not seen this question before. What rights do children have when a parent's ex-spouse tries to hide their death? So
Hide it?
it says hide, yeah, it says hide their death. And I do know in the group there have been cases where an adult child lives out of state
Mhm.
and maybe no one in the family ever contacted them and told them that the parent was sick, or maybe
Oh,
even in some extreme cases where the parent passed.
yeah,
Um,
that's really
do adult children have rights? And it says ex-spouse in this case too,
yeah,
so not even a current spouse.
yeah. So, again, there's more questions than answers right now. I want to know if it's rights to assets, if it's
Mm,
rights to sue them for emotional distress, kind of, we need
right.
a little more information. So whoever wrote that question, you can contact me and talk to you.
Okay.
Um, But what I would say generally is that spouses have rights and adult children have rights. And whenever
Mm-hmm.
we do a probate in Minnesota, one of the required notices is to email the surviving spouse and the adult children and the minor children notice of their rights. So everyone
Mm-hmm.
does have some rights, especially in a case where there's non-joint children. Oftentimes, if it's a surviving spouse, the surviving spouse gets a life estate in the house, but ultimately the children get the remainder interest. So the general answer is usually you have rights.
Right.
If this was an ex-spouse doesn't have rights unless it
Right.
was a divorce decree that said life insurance is going to pay for this obligation.
Mm-hmm.
If there's a will that a divorce undoes will undo all of that. So that's an interesting one. So to whoever submitted that question, if they want to call me, I'd love to
Okay.
talk about it. Yeah.
Absolutely. Um, we'll do one more from Facebook. How can family members address situations where a signature on documents seems suspicious? And they said, like when a bedridden person supposedly signed something perfectly.
Yeah, so absolutely bring that to court. So if the person is still alive and they don't have capacity and you think that someone is having them sign things that they don't know,
Hmm.
go get a guardianship conservatorship and have the court declare that all of those documents were signed
Oh,
under, like, didn't have capacity and are invalid. Okay. So if they're still
sure.
alive, go to court, guardianship conservatorship. If they've passed away and you think that someone is presenting a will or wishes that were signed without the person having capacity, or if they were unduly influenced, you can bring that to court and have it thrown out. So there are
Okay.
remedies for both those situations.
Excellent. And so it seems like the underlying answer to almost all of these questions and the advice I commonly give is make sure you speak to an attorney. Like just take a little bit of time, just take a little bit of time and speak to an
Yeah,
attorney.
exactly.
Oh, that is excellent. Heather, before we part ways, is there any other advice that you would like to leave for some of the families who will be listening to this video?
Yeah, absolutely. So I think one of the best gifts that you can give to your loved ones is to plan for what's going to happen immediately after you're gone. It is one of the hardest things to face. No one wants to do it, but I can guarantee that it will make your loved one's life while they're grieving the loss a lot easier and smoother. If you're concerned about paying for an attorney, I totally get that. But if you're upfront about it, there are so many different firms in the Twin Cities and around, and so many different rates. And if you're just upfront and honest, like, this is my need, this is my budget, you'll
Mm,
find someone that will help you. Not all attorneys are requiring an upfront retainer.
right.
A lot of times I'll work with you and then send you a bill later. Not all attorneys are just what you picture when you hear the word attorney. Some of us have very kind hearts and are here to help. So don't be afraid to reach out. Don't be afraid to be honest about your budget, honest about your needs. I at least will work with you, and I know there's other attorneys in the cities that would as well.
Excellent advice. And even if you're not in Minnesota, go online and look for some similar resources in the state that you're in, because I've heard of some services like this in other states as well. And so definitely, that is great advice. Our guest today has been Heather Balgaard. She's an attorney at Monroe, Moxness, and Berg. And Heather, how would you like people to get in touch with you if they have more questions?
So our website, if you just Google Monroe Boxesburg, my phone number and my email address are on there, as well as my legal assistant. So I answer my own phone, which is very rare for attorneys. So if you just call me and I'm not tied up, I will answer and I'm happy to chat. I do offer free consultations, and so that's usually a free phone call and then a free meeting. And then we decide what our relationship is going to look like moving forward. So please reach out. And then I'm sure in the comments on the YouTube page, we can put my contact information
Sure,
in.
absolutely. We will include a link to your website and your contact information. We'll put that right in the show notes. And Heather, this has been really, really helpful today. I got to believe that you saved at least one or more people a lot of money. And so we really, really appreciate it. And thank you very much for coming on the podcast today.
Yeah, thanks for having me.